Hello to the members and friends of the Italy America Chamber of Commerce of Texas. I hope everyone is well. My name is Frank Cerza. I'm a corporate and real estate partner at the law firm of Lewis-Brisbois, Biscard & Smith. I'm also a member of the board of the Chamber of Commerce. I'm speaking to you today about the impact of COVID-19 on retail store leases. As we all know, the coronavirus has wreaked havoc on our economy and the way we actually live. It's unprecedented. There has never been a time like this, and landlords and tenants are scrambling to reevaluate and assess their respective obligations under their leases. There have never been this many mandated store closures by governmental authorities, which presents very interesting and novel issues. The clause in the lease that most often is affected by this type of situation is called force majeure. And force majeure clauses are a creation of contract and not by common law. So if the clause is not in the lease, then it's not applicable. The normal incidents of force majeure are strikes, acts of God such as water, storm, earthquake, government intervention, and things of that nature. In the contract of force majeure in the lease, the parties must enunciate the exact acts, even though unforeseeable, at the time the contract is formed. So, for example, if a provision has a certain number of enumerated acts, and that act, even though it's unforeseeable but happens in the future, then it's given coverage. It's very unlikely that most leases talk about pandemics, so this is a very, very novel question in our time. I'm sure in the future that landlords and tenants will address that. If enumerated, then there is coverage, and normally performance by the tenant is suspended or excused for the period of time that the act is in occurrence. So, for example, assuming a tenant had an obligation to open its store or to complete a certain construction, and there was a government-mandated COVID-19 closure, the tenant, for 60 days, the tenant would get an extra 60 days to complete their act. And that's the normal coverage of a force majeure provision. But what about rent? Is rent covered by force majeure? Very interesting question. Most modern leases have excluded rent obligations. Why? Because landlords have classically taken the position that even though an act may have occurred, unless there is a closure of a bank, a tenant can still pay the rent. So let's think about it. The government ordered mandated store closures. Tenants can still pay their rent, although it's an outrageous proposition because tenants would say, well, listen, I can't operate my store. How am I going to generate sales and revenue to pay your rent? It seems to be a little bit of a disconnect between the excuse of a normal force majeure provision, which is performance. But as a technical matter, rent may be able to be payable even though your store is closed. Seems like an unfair result, and for sure, there is going to be a lot of litigation in the future. Now, the other thing that is very important to consider in this time is government orders. And there are many, many in different states, and they're constantly changing from day to day. There is even, as we speak, a bill that is being introduced in the New York Senate to forgive rent for a period of 90 days. So tenants won't have to pay rent for 90 days, and the bill also provides that landlords won't have to pay their lenders their mortgage amounts for 90 days. So there seems to be governmental intervention afoot to try to give both landlords and tenants some coverage. No one knows if that bill will ever be passed. Some bills are just delaying and postponing rent for a period of time. In any event, the most important thing, I think, is for landlords and tenants to be in constant communication. Since it's unprecedented and nobody really knows where this is going, I think that landlords and tenants are necessarily have to work together. It's very important that if a solution or a workout is crafted between a landlord and tenant, that both parties take into account that whatever provisions they agree to, whether it's excusing rent or delaying rent, that they recognize that there could be future laws there that are enacted which could change what the parties agreed to today. So, for example, if the landlord and tenant agreed to a half rent abatement, so to excuse or forgive 50% of the rent, and tomorrow a government enacts total forgiveness of rent, a tenant might be bound and a landlord by that provision. So careful attention should be given to taking into consideration future laws. You may also want to make insurance claims. Most landlords and tenants have insurance policies. There may or may not be business interruption insurance coverage or civil authorities coverage. But you should always consult with your attorney and your insurance advisors to see if there's coverage under your leases with regard to force majeure and insurance claims. Well, I wish you all the best, and I hope that you're safe and well. And this terrible pandemic passes quickly, and we can get back to business as soon as possible. Stay well, everyone. Thank you.